Be ready? Start. The requirement of sealing the recorded conversation would not be applicable in this case. Stop. That requirement is of a sense in the criminal case where during investigation the conversation of a party is recorded by the investigating officer. Stop. He would certainly be required to seal the tape recorded conversation and keep it in a safe custody so as to play before the court at the time of trial. Stop. When the defendant himself has recorded the conversation of the plaintiff as a party in a civil suit, who is required to keep custody of his own documents, there is no question of the requirement of sealing. Stop. It has nevertheless to be shown to be accurate and untampered with. Stop. This is in line with the only requirement of the court, which is to ascertain the truth of the case of the parties. Stop. Once the court is satisfied about the truth of the tape recorded conversation, it can be used in evidence to determine the case on merits. Stop. Consequently, the observation of the court in paragraph 3 of the judgment in the case of Putholi, that the conversation of the witness on a tape recorder can be shown to the court by producing the tape record in support of the assertion that certain statement was made in his presence, rules out any further requirements and formalities except for showing the accuracy of the tape recorded conversation. Stop. In fact, the observation of the court in paragraph 7 of the judgment concluding that the tape record was admissible as primary evidence with the aforesaid provisos of accuracy, identification, and relevancy shows that it was on par with human evidence once it is replayed in the court or proved by forensic evidence. Thus, stop. Each received it at the same time, the one recording it in the human memory, the other upon a piece of tape. Stop. Consequently, it has considered the judgment of the Supreme Court in the case of Rama Reddy, in which it was held that the previous statement recorded on tape could be used not only to corroborate the evidence given by the witness but also to contradict the evidence given before the court, as well as to test the veracity of the evidence and also to impeach his impartiality upon holding that it was primary and direct evidence admissible as to what has been said and picked up by the recorder. Stop. Further, it is observed that the production of the tape recorded conversation to comply with the aforesaid provisos can be made in the mode stop, there can be no straight jacket formula stop. Therefore, it would be vain to suggest that because the CD was not sealed prior to its production, it can be admissible or used in evidence stop. This is a civil trial stop. The defendant himself has recorded the conversation and produced the CD thereof stop. The defendant could not have recorded it directly on the CD stop. The plaintiff had to have an electronic process on an electronic instrument to record the conversation on the CD stop. It is for the plaintiff to produce it stop. It is for the court consider and appreciate it stop. There is no question of sealing of a conversation recorded by a party to the civil list himself stop. The sealing requirement is only in criminal trials stop.